It's very important because for the first time, a group of in-house lawyers have come together. It's not quite in their training to come together.
Mm.
I mean, they come together for conferences and so on, but really come together. I mean, they're trained as solo players, warriors, individual micro businesses. And so the whole notion of coming together and sharing, I mean, they're notoriously shouty with each other. I mean, so to get them to come together is amazing, and to express their feelings, their needs, and what they want done. One of the tools developed by others, not by me, that I feature in the book at length is feel, need, do. Lawyers like this; they find it useful. Found over the years because the F word, feelings, have been trained out of them in their legal training. They've been trained to think, not to feel. And so I reconnect them with their feelings and their needs and what they want done about stuff. But the thing about this response was that they came together and expressed their feelings. Now in the book, as well as including the entire response in the appendix, I extract, using ellipses, all of the feeling sentences in their letter. And these are really interesting, and I kind of pick out a few because it's important to recognize, as one in-house lawyer called it over the years, the omerta-esque silence of the in-house lawyers was now broken by this letter. And the three feelings I would pick out was, and this was explicit in their letter, not in no way ambiguous. So the first thing was they say that the SRA does not appear to see the extent of the challenges that they're experiencing. Now, this is the equivalent of, Oliver Twist saying, like, more.
Mm.
I mean, this is unheard of. I know it didn't make the front page of the legal press.
Mm.
I mean, this is only 33 in-house lawyers of 34,000, admittedly, but nevertheless, they turn to their regulator, of which they are understandably a bit fearful. But they were saying, you do not appear to see the extent of the challenges we face. That's a big statement by a group of professionals. The second thing that I think was really explicit, I was delighted to see this because I had been beating this drum for some time, but I'm not a lawyer, so it was no good me bleating on about this issue. It was important that they did so. And they said that independence is at the very heart of the tension in the client-employer relationship. Independence is at the heart of the tension. So this was an explicit acknowledgement of the thing I and others way before me and far better than I, academics particularly, were articulating this tension. Professor Stephen Mason called it the inherent tension, or the tension inherent. And Professor Richard Moorhead, who's written the foreword to the book, he's written extensively on this tension. And so for me, it was incredibly important and a milestone, actually, that they were saying this out loud. And the third of many things, by the way, there's lots of things they point out, was there was explicit, now, albeit in very lawyer-esque, and I would say that they won't be very happy with this slightly tortuous language, but I understand why. They address the resign or conform culture, which is the thing that shocked me most, and I say so at the beginning of the book. And they say most would find it difficult to accommodate a binary or subtle decision between enabling a course of action. Most would find it to accommodate domestically. Of course, by domestically, they mean about how they might earn their living. Mm. And between enabling a course of action and or resigning.
Mm.
And so that's big stuff, isn't
Yeah.
it?
Absolutely.
You know, if and this is what they are, these are not my words.
Mm.
And it's not that this had come up before. I mean, it had been socialized on LinkedIn a couple of times previously where people said, you need a plan B. I was horrified. Why would a professional need a plan B? What if you couldn't afford a plan B?
Mm.
You know, what were we talking about? Lawyers and in jurisdictions across the world where we don't have the privilege, which is an interesting word in other contexts, of having, they don't have lawyers at all.
Mm.
And here we have a context in which their very independence and their livelihoods, or as Stephen Mason, Professor Stephen Mason says, the chilling, he uses the word, the chilling impact of calling something out, of the potential chilling impact of confronting some of the issues. And so to answer the question in short, in brief, is that the response, this genie isn't going back in the bottle.
Mm.
It just isn't. It's there. Everybody can see it. They've said it. And in the book, it made a huge difference to me because I could quote their words. And they mean them. They really, really mean them. They were outraged, although that's not a word they used. It's a word I used. But if you read the response, you know, I think we are particularly troubled by the fact that the SRA does not appear to see the extent of the challenges for in-house solicitors that the review signals. I'm not a lawyer, but, you know, that's unambiguous. Struntled of Tunbridge Wells, isn't it?
Absolutely.
You know, I'm not making this up. This isn't me being shouty. This is them being shouty. And good for them. And I hope more and more of the 34,000 in-house lawyers join them. That's why it's important.